I am in lovely Nebraska today, where it is a delicious and wonderful 25 degrees here in downtown Omaha. And tomorrow I will get to enjoy 11 degrees. So awesome. Let's talk about our year in review, usually one of my most favorite presentations that we get to do. Just remember, this is not advice as to any particular matter. I'm going to talk about a lot of cases. I'm going to talk about a lot of predictions about things that are going to change or things that we're watching. Again, don't take any of this too seriously, people. I am just here to have fun. Tip your bartenders. This is a continuing legal education qualified course for 1 hour of credit. I have to make this announcement. You have to be present. We're going to take electronic attendance. Everybody who's there in person, but I guess no one should be there in person because I'm not even there in person. Normally we would take a written attendance. Just a quick heads up though, by the way, on CLE credits. The CLE Accreditation Board has just changed the rule. And so effective January 1, 2026, for attorneys with less than 2 years of experience, there's going to be a rule change, and you have to be in person to get CLE accredited courses seated in a group. So just expect that in January, if you're a LOIS attorney, we're going to give you some advice on how to comply if you have less than 2 years of admission to the bar, which I think really relatively few of you do. All right, let's jump in. Welcome to the year in review. Let's talk about the exciting stuff that happened in 2025, and let's talk about ourselves first because why not? LOIS Law Firm turned 10 this year. That's kind of awesome. So thank you everybody on our team for being here. I know at our holiday party in a few weeks, we're going to be recognizing a lot of people who've been here for the full 10 years. So thank you for everything you've done, and thank you for clients. Without you, we wouldn't be around. I want to congratulate Christian Cison on his Third Fridays podcast, which if you don't listen to it, you should. They just surpassed 30,000 downloads of that podcast last month, so that's pretty awesome. So congratulations to him. This year, we reported a lot of wins on our website, a lot of wins. In fact, so far in 2025, we've reported 188 wins, and thank you to all of the attorneys and paraprofessionals who are out there creating leverage and creating success for our clients. When we look at those wins, the biggest category of wins have been in the area of fraud. More than 20% of the wins on our website involve us detecting or leveraging some form of fraud. The second biggest category was labor market attachment. And then the third biggest category is, I'm just going to call it trial testimony or trial results, or just being a good attorney or being a good paraprofessional preparing for trial correctly. It's our cases where we did a great job on cross-examination and got either a reversal or a reduction or created some leverage for our clients. So that's really great. All right, let's jump into the topic of New York workers' compensation. We'll stop talking about ourselves for a few minutes. I'm going to talk a little bit about benefit rate updates, what's going to happen in July. I want to talk to everyone about what's happening in the RICO cases. And then I'm going to start going through the case law. I reviewed about 100 cases for today's presentation. And I just picked out the ones that I thought were really interesting or were unique or were going to help us practice in 2026. Sorry. All right, so let's quickly first turn to benefit rates. We know that the benefit rates are now fully pegged or indexed to the New York State average weekly wage. This began last January, where they're now starting to slide up the minimum rate. The minimum rate is currently $325 per week. It is going to change in June, on June 30th, not June 20th. Sorry, that's a typo. On July 1st of 2026, for the first time, the minimum rate will be indexed to 1/5 of the New York State average weekly wage, or the employee's actual wages, whichever is less. Now, let's take a look at what that means. Just remember, a few years ago, 2 years ago, the minimum rate was $150 a week. Then it went to $275 a week, then $325 a week. And based on the trends, we don't have the 2025 New York State average weekly wage calculated yet because the Department of Labor hasn't calculated yet. But if we use the 2024 New York State average weekly wage, the rate will be at least $366 per week minimum starting in 2026. So expect that to all change in July. As we get closer, usually in April, the board will make the announcement of what New York State average weekly wage calculation they're going to use to form the basis for setting the benefit rates for that July. So expect information from us in April about what we expect these rates to move to. All right, let's move on to one of my favorite topics. And we've had a lot of discussion with you clients and internally in the office about the wonderful RICO cases. You know, whenever you make a law strict liability like the workers' compensation is, you know, it's a no-fault law, and then you grant a lot of presumptions, and Section 21 grants a lot of presumptions to the petitioner or the claimant, what happens is you invite in a lot of fraud. And one carrier, tradesmen, started pushing back against that in 2024. And they filed a number of RICO suits alleging that there was collusion between doctors, lawyers, and claimants, and that were targeting workers' compensation cases and construction cases in New York to defraud insurance carriers. After they filed their lawsuit, there were a couple fast follower lawsuits. In re Ionian is one of those groups. Uber's filed a lawsuit. So there's a number of these. In December, a couple weeks, the two most developed cases got dismissed with prejudice. They got dismissed last month. Sorry. They got dismissed with prejudice. They're going to be appealed. They're going to go up to the Second Circuit. Now, the theory of the court dismissing them was that they couldn't show a loss. That, in other words, for a RICO claim, you have got to demonstrate, hey, there's coordination among these bad actors and they're committing a crime, which was the fraud, which was the employment of runners, which was the employment of crooked doctors and fake medical reports, all these things that they were doing that are illegal and that they were doing this in a coordinated fashion. But you also have to show that you've been harmed by that activity. And the Eastern District of New York, dismissing the two claims that they dismissed with prejudice, said that the alleged financial harms do not constitute a cognizable injury to business or property. Now, the claims at this point have alleged about $1 billion in losses. So I don't know how there isn't an allegation. That doesn't count as a financial harm. It certainly does. They're claiming loss of premium and having to pay out indemnity benefits that they wouldn't have had to pay. So again, this is something that is going to have more development. Again, this is on appeal. And what happens on this appeal is going to set the precedent for the many fast follower cases. By my count, there's at least 7 fast follower cases that allege essentially the same RICO predicate case that the original tradesman case is doing. The Ionian cases that are pending against the Subin and other law firms like the Liakis law firm and the Goriev law firm, those are also at risk, right? Because and you can see that what's happened is the litigation has sort of slowed down in the other cases because everyone wants to see what's going to happen on these leading appeals. So as you can expect, these are big cases with a lot of eyes on them. Expect to get a lot more information from us this year as this continues to develop. All right, now let's turn to New York workers' compensation case law and developments. And I'm just going to say this. If you're looking for a particular case, and I hurt your feelings because I didn't cover it today, I can't review every case that came out this year. First of all, there was hundreds of trial level decisions, and there was probably about 100 appellate level decisions in total, maybe a little less than that. To keep this relevant, I tried to group discussion of cases under topics, and I'm only looking at appellate decisions or court of appeal decisions. I'm not spending my time looking at board panel decisions or even, I would never look at trial decisions, but I'm not even looking at the board panel decisions. My goal is to talk about where a standard is either explained or distinguished, and then to try to figure out how do we apply that to our daily practice, okay? So some of these topics you're going to say, like, Greg, I don't really care that much about attorney's fees, which is my first case that I'm going to talk about in a minute, but it is going to affect the way we practice, and so that's why I'm going to talk about it. So the first case is on, I'll call it representation, but it really goes to attorney's fees. And in this case, it's called N. Ray Pandolfi. The claimant's counsel was actually fired by his client, by the claimant, as the workers' compensation case was pending. He was actually fired during the pendency of the case. Claimant went pro se and ultimately won an award. They won a scheduled loss of use award. And after the case is closed and everything's paid out, now claimant's counsel comes forward and goes, oh, wait, I think I'm entitled to a fee. And this is an interesting thought. Hey, you didn't represent them at the time that the case was stipulated or settled. Why do you think you're entitled to a fee? Well, in case you were wondering, the appellate division says that yes, even in pro se cases, where they're pro se at the time of the settlement or stipulation, if they were ever represented, the attorney can come forward and or make an argument that they're entitled to a fee. So our advice is going to be, and the takeaway is going to be, hey, if you have a case that's settling pro se or stipulating to a settlement pro se, stop for a second and think, hey, do I have to address this attorney who's either withdrawn or was relieved of counsel before they became pro se? Do not ignore it, because then your case could have to get reopened just for the issue of that attorney coming forward and saying, hey, I want my fee. And remember, never underestimate how greedy an attorney is going to be to try to grab their fee. All right. Next, let's talk about intoxication, one of my favorite topics in workers' compensation law. Of course, it's intoxication defense. You know, we all know what it is. I love applying an intoxication defense, but unfortunately, it's a little bit like a unicorn. Everybody knows what a unicorn looks like. No one's ever seen a unicorn, and so it's very difficult to win an intoxication defense. Why? Because the claimant has 5 presumptions under Section 21 of the Workers' Compensation Law, and one of those presumptions is if they were intoxicated at the time of their accident, the intoxication is not presumed to be the sole cause of the accident. All right, so this case that we're going to talk about now is Romali's versus Frank's Pizza. Unfortunately, this is a LOIS Law Firm case. We had a case in which the claimant was a dishwasher, fell down some stairs while carrying a pot filled with hot pizza sauce. So not only was it embarrassing and silly and did he get covered in pizza sauce, we also got some pretty significant burns from this injury. Now, the employer testifies, says, look, we knew this guy was drunk. We told him not to be doing this. We told him not to drink at work. We told him not to use the stairs always. We said, don't carry hot things up and down the stairs, but he did it anyway. He ends up getting injured. At the hospital, they took his blood alcohol, which came back as 0.281, which I think is more than 2.5 times the legal limit for intoxication. Of course, we raise intoxication as a defense, and we did win at the trial level, so go us. Unfortunately, it gets appealed up to the appellate division, and the appellate division says the employer did not overcome the presumption that the intoxication was not the sole cause of injuries. The appellate division says essentially like, yeah, maybe he was really drunk, but he was also carrying this really heavy hot pot, and that combined with his drunkenness is what actually led to his incident, his falling down the stairs and then burning himself. So it's obviously a disappointing outcome that was reached this year. But again, I think it shows the power of those presumptions and how difficult they are to overcome. Our job, our goal in that case was to show that the intoxication by itself was the sole cause of the accident. Very difficult burden to meet. And of course, the burden of production is on us, the defense, when we raise an affirmative defense for which the claimant already has a presumption. So just a challenging set of facts, which led to, a decision that is along with the main body of law in investigating intoxication, in which the court bends over backwards, essentially, to figure out ways how the claimant's own massive intoxication was not the sole cause of the loss. All right, let's move into a broad category of cases that I'm going to categorize as labor market attachment, and then I've got some voluntary withdrawal cases as well. And I just want to show the amount of work that needs to go into a labor market attachment defense case, and how we've got to pursue everything we can, and also the importance of trial testimony and pursuing a case to the end. So let's talk about the first one, Jover versus Alba. This was a New York State Insurance Fund case. Claimants classified, okay, so they're already classified at a 75% LWEC. The claimant has to demonstrate, though, that he is attached to the labor market, and the judge directs him to do that, and he does. So he submits a whole bunch of C-258 forms. Now, The argument, sorry, this was not our case, but the argument was that he failed to make the showing that he was attached. The board agreed that he failed to demonstrate attachment because he was applying for jobs that he was not qualified for. And particularly what they looked at in this case was that he was not proficient in the English language. So it's not that he wasn't applying for jobs, but he was applying for jobs that were really a practical impossibility for him to obtain. He admitted on cross-examination that he had not participated in any job location services and he had not made any attempt to develop English language or computer skills. And he applied for jobs that were just frankly bizarre and ridiculous, like being an optometrist, working as an English-speaking paralegal, working as a social worker, and the craziest one is working as a Bengali-speaking marketing specialist. So the board clearly found, and after he testified, that he was not qualified for any of these things. He was just applying for jobs, and he applied for many, many positions, by the way. I think the record shows that it was more than 100 positions that he applied for, but none of them were valid. Again, labor market attachment is one of your strongest defenses. Think about it. In this case, the employer was hit with a 75% loss of wage earning capacity and then intelligently raised attachment and got it all thrown out and doesn't have to pay, at least until he becomes attached because he didn't have a valid work search. So again, to me, that demonstrates the value of some hard work and doing a good cross-examination. Let's talk to the kissing cousin of labor market attachment, which is voluntary withdrawal. Now, we've got this case involving a New York public school teacher, Hurley, versus the Lawrence School District. He claims that he has causally related asthma, and the case was actually established for him developing causally related asthma to working in a school, so that there was like some dust and mold and pollen in the school, and he was exposed to it. Okay, so that's resolved. It's time to come back to work. And they said, listen, we're going to put you in a position where you can stay in your same air-conditioned classroom all day, and you never have to leave the classroom. You've got a separate air conditioner in there. You're not going to be required to do any of the other duties you have to do. He did come back to work, and he only worked 4 days. And then he said, I'm sorry, there's construction going on in this building, and sometimes the dust comes into my classroom, and it's going to trigger my asthma. I can't work in this building. And, of course, goes back home, hides out, sits around, drinks beer, and watches Judge Judy all day. Well, the school system said, well, we're not going to just do nothing. And so they offer him a new position. They move him to an air-conditioned library in another building where all he has to do is sit in the library all day, where there is absolutely no construction present. They do a really good job of sending him a good offer letter, explaining what the job is, describing where he's going to have to report to, and that there's not going to be the presence of any dust or pollen in there that could trigger his asthma condition. Well, he just doesn't respond to it. Now, the interesting thing is he had accumulated a lot of sick days and was taking sick days during this whole period of time. And so he never acknowledged the reassignment, never accepted the new work offer, and just never came back to work. They cut him off. The judge agrees. He then appeals, saying this isn't fair. There's no way I could work in this library. I have new medical evidence, etc. And the appellate division said, sorry, you voluntarily withdrew from the labor market. I think this case demonstrates the importance of, hey, if we're going to make an accommodation, documenting the accommodation, making sure it does meet with their restrictions. And then if they still fail to comply with it, you're on solid ground to get that case stopped or dismissed. All right. Just a quick aside on World Trade Center claims. We do have a bunch of them that we're still defending. The appellate division ruled that the 2-year statute of limitations for filing does apply to a death claim arising under the World Trade Center Claims Act. So I think that's the first decision that states that the 2-year statute of limitations applies. And I think the reason this was, so questionable is because every year they keep just expanding the time for filing and for notice in World Trade Center claims. All right, let's talk about experts and preclusion next. This case involved a claimant's doctor. I don't know why my screen just got dark. There we go. Who found a 42.5% scheduled loss of use to the hand for a wrist injury. Okay, the claimant. This case is in re Triano. It was just decided a few weeks ago. The employer, for whatever reason, did not get an IME. Shame on you. You should have. And the judge just said, okay, I'm going to accept claimant's doctor's finding and I am going to award a 42.5% scheduled loss of use, which is a pretty high award. On appeal, the employer argues that the claimant's doctor was actually an IME and should have been precluded. And they argued this essentially was only seeing this doctor not for the purpose of treatment, just for the purposes of getting a permanency number, scheduled loss of use number, so that it could get a award or stipulation. The board agrees and says, okay, you're right. He only went to this doctor once. Really, the Section 137 rules, which apply to IME doctors, should apply to this doctor. He didn't follow all those requirements under the statute. Example, notice, delivering the report in a specific time, a specific matter within 10 days of doing the examination, etc. And for that reason, the board rescinds the scheduled loss of use award, finding that this treating doctor's exam was actually an IME doctor's exam. Unfortunately, it goes to the appellate division, who reverses this and said, yeah, good argument, and you're right, but employer, you should have raised that defense at the time the judge made the award, not after. This defense that, hey, wait a second, this is actually an IME opinion and not a treating doctor's opinion and should be treated differently in court, was not raised quickly enough. All right, takeaway on this one. And I've got all my defense attorneys and paraprofessionals that are listening right now. Guys, this is why we raise every defense early and put them out there on the record, particularly if you have a case where it looks to me, and I'm reading between the lines in the case law here, but it looks like the employer didn't get the IME just because they either were out of time or somebody dropped the ball somewhere. I don't know. But if you ever this situation where you're going to court and you don't have an IME, claim it does have a scheduled loss of use number, I think you've got to keep this argument in your back pocket. Wait a second. Is that really a valid treating physician's scheduled loss of use finding on that C-4.3 form? Or can I argue that that's technically an IME and they should have required with all their rules for an IME, which of course they're never going to do, right? So raise those defenses. Don't sleep on those. All right. I'm talking fast because I got a lot of cases to get through and I want to get through as many of them as I can. Let's talk about occupationals. Interesting case. And mainly I picked this case out because I love pickleball. I just love pickleball. So this case is called In re McGann. This is an occupational claim. He alleged that his exposure over 32 years to his work duties caused him to develop bilateral carpal tunnel syndrome, so both wrists. However, the employer proves that, now, by the way, he brings this claim after he's retired, by the way, okay? And of course, he argues that his retirement was necessitated by the pain in his wrists, but by the way, this is like a classic post-retirement. Let's just see what I can get money for. The employer looks into them and goes, wait a second, before he retired and before the case was established, we know that he's been an avid pickleball player. And we can prove that he's been an avid pickleball player. The appellate division, so the board looks at this and says, okay, well, listen, this doesn't make any sense. You're saying your hands and wrists were injured from work, then you retire, you move to Florida, now you're playing pickleball all the time, and then you bring in a workers' comp claim for carpal tunnel syndrome. This doesn't add up, okay? Doesn't establish causal relationship. However, he did tell his doctors that he played pickleball. They did not relate his carpal tunnel syndrome to the pickleball playing. They related it entirely to his playing, to his work activity. Okay, so that's in the medical records. The appellate division looks at all this and reverses it and says, hey, the doctors were aware of pickleball activity. They still concluded that his carpal tunnel syndrome was work-related, and so it is established, and sorry, you're stuck with these claims. That's obviously not a great outcome for us. And in this instance, I think it kind of turned on the fact that his doctors were not surprised, and on cross-examination said, yeah, we knew about that, but we don't think that actually worsened his condition. We think it was all from work, right? So keep that one in the back of your pocket as well. All right, let's move over to scheduled loss of use and apportionment of scheduled loss of use. Let's talk about this case, which I think it's going to become very important this year because it's going to change the way we look at apportionment for prior disability in New York, particularly in regards to scheduled loss of uses. This case is called Crane versus Greenhaven. It was just decided a couple weeks ago. In this case, the trial judge awarded a 25% scheduled loss of use to the leg, with apportionment of 2.5% for prior loss of use. However, this guy already had an award for 12.5% scheduled loss of use for the same body part. So the employer says, wait, that's not fair. He's already got numbers on that leg, and it should be 25%, if that's the right number, less what was previously awarded. The board agrees and says, you know what, we're going to reduce the award. Genduso applies. We're strictly interpreting Genduso, which they've been doing recently. The claimant then appeals, and now we get this new case law. The appellate division reverses the case and says, you know what, where they have a prior slew to the same body part, it's up to the trial court to figure out if that's actually a worsening of the same kind of situation, the same exact pathology, or different. And they said, quote, it's up to the trial court to determine, quote, is it a separate pathology that individually caused a particular amount of loss of use, close quote. And in that case, they could say, well, none of it's apportioned. In other words, you, employer or carrier, get no credit for prior loss of use, well, which is obviously not good for us. And it reverses the articulated standard that the board has been following under Genduso, which has been, quote, we must always reduce by the amount of any prior slew to the same statutory member, close quote. So this just happened. I don't know what's going to happen next, whether the employer or carrier is going to appeal that further. I think that this is a ridiculous outcome because it's going to essentially mean that in every case where the claimant has a prior slew to the same body part, they're just going to say, my new injury is slightly different than that old injury, even though we're compensating them for loss of use of a body part, not specific pathologies, right? Because that's what a scheduled loss of use finding is, right? It's a loss of function of a body part or member or system. That's what we're compensating, not the injury itself. So it doesn't really matter if the reason you have a reduction in your range of motion or a loss of grip strength is because you have a meniscal tear or because you have tendinitis. It doesn't matter if you have that amount of pre-existing disability. Why would the individual pathology matter, right? So this is one that doesn't make sense. I'm going to keep banging my head against the wall because I don't understand how the appellate division gets it so wrong so frequently. But this is really not good, and it's going to definitely undermine our arguments where we argue, hey, there's a prior slew, we should get a 100% credit for the entire value of that slew. All right, so keep your eyes on this one, and if any further appellate case law develops on this one, and the only place this could go, by the way, is back to the trial court, which could make the same or different decision and maybe get appealed again, we'll definitely keep our eyes on this one. All right, next. Another slew case, Brooks versus NYCTA, which is the New York City Transit Authority. Just an interesting one involving contralateral measurements. So the claimant receives a scheduled loss of use award for injuries to the right arm, right leg, and right foot. The employer appeals saying, hey, this Dr. Heidick, by the way, I put his name in here just so you can see, because we know this doctor. He admits on cross-examination that he didn't compare the contralateral side. His findings are therefore invalid because the disability duration guidelines say you must compare the contralateral side. The treating physician says, yeah, I didn't actually examine. I didn't do that because I knew that they already had problems with the other side. They already had some injuries or disability there, so I didn't think it made sense. Now, admitting that she was not at maximum medical improvement for any other injuries, also admitting that she didn't have any prior classification or slews for any prior injuries to the contralateral body parts. The defense IME did compare the contralateral sites, okay? And this, by the way, was Dr. Lager, if I'm remembering correctly. Did compare the contralateral sites, found identical ranges of motion on both sides of the body, and said, in addition to identical ranges of motion, said, and no scheduled loss of use to any body part. Everything's fine, okay? Trial judge still awards scheduled loss of uses, and of course the employer appeals. The board reverses the trial decision, saying that the comparison was to the contralateral side was necessary, and then that gets appealed by the claimant's counsel to the appellate division. All right, now the appellate panel comes in and says, you know what, board, actually your decision here didn't follow the guidelines, which says you should not do a contralateral comparison when it is, quote, inappropriate, close quote. Now, of course, it doesn't define what when it would be appropriate, when inappropriate, okay? So the appellate court sends the case back to the trial court saying, hey, you got to compare to the that comparison to the contralateral side is not appropriate here because, there's could be other problems. They said, quote, comparing contralateral members that have temporary physical or functional impairments, either due to work-related or non-work-related injuries, would be inappropriate, as such comparisons could equally result in inequitable range of motion findings, period, close quote. So now, imagine this. Claimant can defeat contralateral findings arguments by just saying, oh yeah, I never told anybody about this. I don't have an award for it or a claim for it, but I did injure my other body part, my contralateral body part, I should say, 5 years ago playing softball with my friends. And I think maybe savvy claimants' counsel are going to tell their clients to say that in every instance so that the doctors do not have to compare to the contralateral limb. So keep this one on your mind because, again, it's going back to the trial court, which means there could be another finding and then another appeal. But here's a case in which the appellate court said, yeah, it is inappropriate to look for contralateral range of motion findings where they've had a prior scheduled loss of use, but also it might be inappropriate if they claim they've ever had any injury or disability to that body part. So I don't know how we're going to police that. And again, this is one where we're not getting, I think, any help from the appellate division. All right, let's look at Johnson versus Howmet. This is one of our cases. I kind of will put this in the sort of a kind of win category. The claimant's permanency exam found a schedule loss of use of 70%, pretty high schedule loss of use. We got a defense IME, but our defense doctor said, nope, not ready for a scheduled loss of use, still needs some active care, has not reached maximum medical improvement yet. Claimant then, cleverly, submits an affidavit saying, you know what, I don't want any more treatment, so therefore I am at maximum medical improvement. The law judge goes ahead and finds a 50% scheduled loss of use for a left arm injury. This is a rotator cuff injury, by the way, based essentially on her treating records, which found a reduced range of motion. The board affirms this outcome, and the claimant then appealed to the appellate division, saying, wait a second, I should have gotten a 70% scheduled loss of use and not a 50% scheduled loss of use. Now, we argued that the claimant's permanency exam that they relied on was obviously symptom magnification and obvious fraud because the deficits by the examining physician significantly exceeded the deficits that she had back during her active care before she was even maximum medical improvement. We also argued that the 50% scheduled loss of use found by the judge was also speculative because it was based on the records before she reached maximum medical improvement and therefore was inappropriate really for a permanency rating. The appellate court agreed with us and sent the case back to the trial judge. So we're going to get new proceedings on that scheduled loss of use. And of course, we're going to bring out that symptom magnification in that case. All right, let's move on to one of my old favorites, COVID. Remember COVID, everybody? Remember when we were all hiding and they sent us all home? Well, I guess some of us still are, as I do this webinar to no one in a hotel room on the other side of the country. Anyway, COVID prevalence standard. I hate the standard. If everyone recalls, when COVID was decided, they decided, hey, we're going to make this a compensable condition, but it doesn't really make any sense under any theory of workers' compensation that's existed for the last 100 years because, you know, generally communicable infectious diseases that are not peculiar in any workplace would never be compensable under really any established theory of workers' compensation law for the 100 years that we've had it. So they made up their own standard, the board did, and their new standard was prevalence. And instead they said, well, we don't have to really show that your COVID infection is specific to any one specific causal connection. So you don't have to tell us who gave you COVID. And we have this other problem that we can't really show that COVID's unique to any one employment because we now know it's endemic. Literally everyone's been exposed to COVID, so it's not specific to anything. It's not peculiar to any employment, so it doesn't really fit an occupational exposure theory. So they came up with a new standard, and their new standard was, well, your COVID claim is going to be compensable if you can prove that COVID was prevalent in your workplace. Again, the ridiculousness of this now, that with a year, 5, 3, whatever many years of hindsight we have is obvious. But at the time, people were scared, so they were just doing anything they wanted to do. And this is a great example of you should never let the bureaucrats make any decisions. Anyway, prevalence standard became our standard. And that was pretty broad, right? Because if you just go, well, a couple other people had it, and it was prevalent in the workplace. And of course, it's prevalent in every workplace because remember, it became endemic, right? So what a terrible standard. Well, it seems like the appellate division and the board are starting to walk away from that standard, which is smart. They should, bury this one and pretend they never remembered even coming up with it. That's my advice. New case decided October 30th, Angelo versus Southwestern School. This case explores the standard. And in this case, the board, again, their standard was if you can prove it was prevalent in the work environment, then you can essentially be compensated for having COVID. This case involved a high school janitor who claimed he had exposure to students passing in the hallways who had COVID. It was denied by the school district, who said, no, you didn't. There were very few opportunities for you to be interacting with students directly. No way. And the denial was upheld because there were no proofs offered that there was a high rate of infection present in the work environment. Now, interestingly, he worked in a school, and we all know that kids are relatively immune from COVID, or at least significant, secondary effects of COVID. The court said that his brief encounters with passing group of students fall short of the degree of regular, consistent, and close interaction with the public at large necessary to sustain a finding of prevalence. So now they're starting to define what prevalence means. Again, just a couple of years ago, it just meant, I worked in a place where other people had COVID. Now they're starting to say, okay, well, it's got to be regular, consistent, close interaction with where COVID has infected a large population. Okay, so that's changing, and I think starting to narrow this definition. Again, we don't really see COVID cases anymore, but this is one of those ones where the court just does stuff that's so crazy, and the board comes up with these new standards that it's forever going to annoy me. And you'll probably always be hearing about COVID from me every time they come up with one of these weirdo decisions. All right, let's move on to the main event. Everybody loves to learn and listen about fraud, and certainly nobody more than me. I love Section 114A of the statute. It was added to the statute in the 90s, and now we can, if we prove that there was a knowing and willful attempt by the claimant to mislead a doctor, to conceal a prior condition, to lie to the court, and that was done for the purpose of any benefit, whether that was medical treatment or a lost time benefit, we can raise fraud as a defense. The claimant has to testify on their own behalf, and the judge has options. Okay, the judge can give them a mandatory penalty, which is rescinding awards, money awards, for the period of time during which the fraud was taking place or the concealment took place. And the judge can also do some discretionary penalties, and those discretionary penalties can include banning them for the rest of their life from ever receiving money benefits from the workers' compensation case. Now, interestingly, fraud under our statute does not end their entitlement to medical care, but it's kind of amazing to me. As soon as the money stops flowing, all of a sudden they stop needing medical care. So it really does bring these cases to a conclusion, and it's one of the main ways that we develop leverage in our cases. So we love fraud here at Lois Law Firm, and you can see that on our website because I think it's the highest proportion of our wins that we report, trial wins, are on issues of fraud. So let's start looking at some interesting cases. The first one is our friend Qureshi versus Rite Aid. And this one kind of combines the labor market stuff together with the fraud. This is a gentleman who worked at Rite Aid. Now, this accident occurs in 2017, has an alleged psychological injury that put him out of work. It took several years for them to start challenging this case. They learned that he was the co-owner in multiple businesses with his wife. This is coming from tax returns. He owned an ice cream franchise that he worked at. He also had a co-owner in a business with his brother. And of course, out-of-country trips. And the appellate division went out of their way to discuss the fact that he did all these theme park trips while he was alleging that his psychiatric disability kept him from being able to interact with other people, right? So obviously that's not true. This fraud finding was upheld. This is like one of the most belligerent examples of like blatant and flagrant fraud. By the way, if your claim is you have a psychiatric condition that prevents you from being around people and returning to work, and you're posting on social media that you're at theme parks waiting on lines and having a great time, like your coworkers are going to notice, maybe not the smartest move there. But no one said these fraudsters were smart, as we'll see as I go through some more of these fraud cases. Next case we'll talk about is Agone versus Stop and Shop, decided last February. Claimed injury to his neck from a 2021 accident. Has an IME on the need for surgery related to that neck injury, and the judge directs depositions. During the deposition, and for the first time, the treating physician starts referring to MRI studies from a 2018 or 2017 neck injury that the treating physician treated them for and had MRIs of them done. Okay. Now the claimant gets on the stand and denies ever injuring his neck before. Okay, this is despite the fact that his treating physician has already testified and said, I've got an MRI of his neck, like I know he had a prior injury. Judge says, I don't know, we got to sort this out. Claimant, you are directed to produce HIPAA releases so that the employer can determine what's going on in this case. Of course, medical records are obtained showing that he did have a 2017 neck injury, did go to the emergency room, and we know at least that he had this MRI. Of course, the employer raises fraud, but interestingly, the claimant testifies essentially, yeah, I did get injured in 2017, but it was pretty minor. I just went to the emergency room. I got a little treatment. I just didn't think of it. I wasn't trying to hide it. I just forgot all about it. All right. I mean, I think that's pretty weak sauce, if you ask me. But ultimately, at the conclusion, the trial judge said, hey, you didn't establish that his omission of this injury was intentional, and therefore I don't find him to be a fraud. Of course, the employer appeals that, goes up to the appellate division, who come back and say, yeah, that's not really material misrepresentation. Now, every one of my attorneys that's listening to this, every paraprofessional, please don't be this terrible defense counsel that represented this employer in this case, which it wasn't us, by the way, okay? This is bad, 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 naughty, naughty, naughty. Don't do this. If they had an ISO, they would have seen, hey, he had a prior accident, he had prior treatment. That should have been investigated long before the claimant gets on the stand, long before that you're fighting about the necessity or causal relationship of surgery in this case. So subpoena those prior treating doctors. Don't get surprised during depositions. I mean, that should be jumping off the page. The time to learn about priors is not when their doctor's testifying. It is months before that. It's before you even get the IME, right? This is why we want to get an ISO in every case, so this kind of thing doesn't happen. All right, another fun case. Tirado versus Symphony. 2 claims following alleged 2013 accidents. And I want everyone to think about the fact that this doesn't get resolved and worked out until March of 2025, okay? Defense IME finds very significant disability. The orthopedic IME found 75% disability, and the psychiatric IME found a 50% LWEC. This guy gets 8 years of temporary disability medical benefits. They put him under surveillance, including 5 days of surveillance that occurred on the dates of those IMEs, okay? They then take a look at those IME dates. On the dates of his IMEs, he's using his cane as a prop. He's walking into offices with a cane, but then when he's not at the IMEs, he takes the cane and throws it in the back of the car. He starts lifting mattresses, box springs. He fully moves somebody out of their house into a lifted up moving truck. He's carrying furniture. He's carrying 40-pound jugs of liquid with no problems. And then the employer says, okay, we're going to send these videos to the defense doctors, who then lower their findings to 25% orthopedic and 0% psychiatric, right? So, all right, that sort of makes sense. The trial judge imposes a mandatory penalty disqualifying him from wage replacement benefits for the period covered by the surveillance videos, which, by the way, was 3 years. Okay, so that 12 days of video took place over 3 years. The judge also gives him a lifetime bar, and of course, the claimant appeals. The appellate division upholds this, and again, I think this is the right determination in this case. But again, defense attorneys, risk professionals, everyone in the world, don't get 12 days of surveillance over 3 years and not use it. I hate that. That's one of the things that drives me crazy. Whenever this comes up in office hours or CAPS roundtable or anything, and someone says, I got some good video, but I think we should get some more. I'm like, no, use what you got. Let's get this to an end. This guy got 8 years of temp. 3 years of that temp was paid to him after they had video of him doing work activities and clearly faking his injuries. That's crazy. Do not wait to use your good videos. Don't wait for that perfect surveillance video. You're never going to get a perfect surveillance video. Work with what you got. Use it as fast as you possibly can. All right, next case. This one is so insane that it'll just blow your mind, okay? Registered nurse Carpenter says she got CRPS, which is chronic regional pain syndrome, to her right leg, her left foot, and both upper extremities from a 2014 accident. Okay, and the way this accident occurred, by the way, is she claims that she was working. She works in a hospital. She was moving a patient. The patient fell on her. Okay, all right, well, maybe. But I don't know how you hurt your right leg, your left leg, and both arms when someone falls on you. Like, I can see a back maybe or something, but it's just weird. Okay, so it's just weird. And also the injuries are weird, guys. People, when you see RSD, reflex sympathetic dystrophy, or CRPS, right, chronic regional pain syndrome, or what we used to call it, fibromyalgia, and what we used to call it before that, fake, okay, just your eyes should be open. Like, this is probably something fishy going on in this case, okay? This claimant starts receiving benefits at a 75 temporary partial rate for years, okay? So it looks like for 7 years they're paying them at this giant rate, okay? Finally, the employer goes and gets surveillance video of her and raises fraud in 2021, okay? And they say, look, we want to get a new IME judge because now we have this great surveillance video. And the judge says, oh, I agree. So they send her to another IME after they've already raised fraud. And here's where this case gets insane. So they're sending her to a doctor for an IME after they've raised fraud based on video. And they once again put her under surveillance at this repeat IME after, again, they've raised fraud, okay? The doctors look at these reports, and she once again clearly has no problem, goes to the IME, fakes it once more. The doctors show that are shown the video, and the insanity to me is that she still, even after she was alerted to the fact that they had gotten surveillance on her in the past, goes to the IME. They again caught her exaggerating her condition and malingering and presenting herself differently to the IME doctor than she was acting in real life. Okay. The trial judge finds mandatory discretionary penalties, and of course that is affirmed by the appellate division. And again, that's the right outcome in this case. But again, the big takeaway here is this is a questionable case from the beginning. I'm sorry. Every single case you have in which the claim is one of these nonsense neurologic disorders for which there's no blood test or real imaging study that can be done. Okay, I want us to have extreme skepticism about these cases. This case should have been red flagged. She should never have gotten 7 years of benefits to pretend that her hands didn't work, which is, by the way, what her claim was. You'll never be this lucky to have a claimant that's this stupid. Again, she's a registered nurse, which is clearly a very dumb individual, very dim, because she should have been alerted. Hey, they've already surveilled me once. They're probably going to do it again, and she committed obvious fraud again. So maybe they're stupid, maybe they're frauds, maybe it's a combination, but you're not always going to be this lucky. So I think we have to be a lot more careful in our cases and really go after those red flag cases. All right, coming up to the end here, last case, and this is going to show the benefit of keep that investigation going. I don't like the outcome of this one, DeBurn versus Pittsford, but I like the tenacity. Okay, so here's a case in which the claimant was classified as permanently and totally disabled as of 2007. So that's 18 years ago, right? So think about where you were 18 years ago. That's how long ago this gentleman was permanently and totally classified as permanently and totally disabled. In 2022, so 15 years later, the state insurance fund starts looking into him and discovers he's operating a home renovations company. So they hire an investigator who poses as a homeowner, calls up the claimant, who then comes to the fake house, dressed in a shirt with his name, the company logo on it, and provides an estimate for home renovation work. Of course, this carrier raises fraud. And again, the thing that's important to recognize here is this is post-classification. In fact, this is post a finding of permanent and total disability. You're still being tenacious and looking into what's happening in these cases, okay? Carrier raises fraud. Claimant testifies and, again, doesn't realize that they set up this whole home renovation opportunity and denies doing any work activity. Okay, now here's what this gets really insane, but again, I got to bring this to reality and tell you this is how things actually work. The board only penalizes him for a 6-month time of benefit rescission, finding that he did commit fraud, but it was only committed from the time that they filed the request for further action, raising fraud, until they had the hearing. The employer, of course, appeals this correctly, says, hey, this guy should get a discretionary lifetime ban. The board panel denies the lifetime ban and says, the investigator's surveillance and the interactions don't really show him performing actual work. He was just doing some estimating work, and that's very light, so that's not inconsistent with his permanent total disability. What? Crazy. The panel does not disturb this ruling. And again, I think this is one of those instances where you have to look at these cases, and even if they're closed, but you think that there's something questionable about them, we should go after that. All right. Let's conclude. Let's say goodbye and talk a little bit about what's going to happen and maybe make some predictions for 2026. All right. So what's next from Lois? Well, the first thing is over the last year, we have built out and staffed up a full auditing department. We now have 6 full-time auditors. We don't call them that. We call it the Client Success Department because it sounds a lot nicer. And it's our challenge to measure our own levels of service. And it's something that we're really proud of and that we're working towards refining all the time. So this Client Success Department, we have these internal auditors that are looking at the quality of our work. The cadence that we're doing at this currently is we're auditing 200 files a month, 2,400 cases a year, which is about half of our total caseload is going to get audited every year, which is pretty awesome. So we're pretty excited about that. And the other thing we've done over the last year and a half is my partner, Tashia, has taken the lead on kind of client compliance issues. And she's also taken the lead on doing portfolio reviews and individual file reviews for clients. We say, hey, I want to take a look at this subset of my portfolio, or I want to just look at some grouping of my portfolio, maybe by year. If you're interested in that, we're very excited to offer you any of that kind of information or have that kind of review with you. So, please feel free to reach out to us about that. The other thing that we're looking forward to and we're investigating and testing and, kind of being very careful about is artificial intelligence, LLMs, or GPTs, whatever you want to call these things. I hear those terms used sort of interchangeably. We don't think they're ready for prime time yet. Okay, it's a big yet. It's getting a lot better, by the way. Back in September, I did a presentation with a panel of attorneys from all across the country with all sorts of live tests of what AI can do and what it cannot do. Currently, it is banned in our practice. We are not using it at all here at LOIS LLC. But as the safety improves and as more and more of these models that are good models, that are the large models, become available to run on private hardware, meaning we could run it in our own data center, then we would maybe start to explore doing that. But right now, not ready for prime time, should not be used at all, and that should never be used to replace legal judgment. So we are not using it in our practice. And I'm going to just put the word comma yet, okay? But I think 2026 is the year to maybe start to explore the use of these. What else is happening in 2026? Well, our education and continuing legal education for attorneys will continue. Our webinar series, that's this series, will continue. We are onboarding new employees in February, so if clients want to attend those onboardings, you're always welcome to attend live in our training center, in our Paramus HQ, or via video conference. And we have a really great lesson book that we follow. We also do, if you're interested, a New Jersey workers' compensation webinar series that follows my practice guide that I write every year for LexisNexis. Hint, my co-author, I think, is going to be a judge soon. So I think that this might be coming to the end of this book, as we maybe in the future don't offer to give away all our knowledge to every member of the bar. But it will continue for the foreseeable future. So if you're interested in New Jersey workers' compensation law, please join us with that. All right. I hope everyone has a great rest of December. I'm here in Nebraska for the rest of the week. It's supposed to be a nice, lovely 11 degrees tomorrow. If I do not see you, have a great holiday season. Have a great Christmas. Have a happy New Year. And we'll see you in this webinar series next year. All right. Bye, everybody.